Step one, wake up early, gonna rise with the sun. Step two, get some good, some food in you. Step three, think real hard about what you wanna be. Step four, everybody just do your thing.
Wake up, today's gonna be a good day. 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 Yo. Set your affirmations, aspirations. I got shit to do, the aftermath of preparation. Good food, good mood, blood in circulation. One step at a time, yeah, that's how you make it. Set a goal you control and the steps you take them. I try to pick one thought, have some concentration. And if I make a mistake, it's called education. I try to do this every day, call it replication. Wake up, today's gonna be a good day. 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 So life ain't easy, yo, I think there's a reason though. Ups and downs, just like every different season, yo. Sometimes I'm high, other times I'm barely breathing, though. I always gotta fight and hide from the demons, yo. Negative thoughts are poison, they rot. Head full of flies, so here come the clouds. They'll never stop unless I can swap all the bad for the good in my head when I'm lost. Yeah, so I'ma fake it till I make it. Positive thoughts are overtaken, I got patience. One day at a time is how you operate a cadence. A flow, you grow, you show yourself a foundation. Stay away from all the shit that causes temptation. I know that I like to do it cause it's sensation. I live my life in my head like a narration. Don't expect greatness, do my best, man, I'll take it. Wake up, today's gonna be a good day. 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 Wake up, today's gonna be a good day.
Wake up, really gonna rise with the sun. Step two, get some good, some food in you. Step three, think real hard about what you wanna be. Step four, everybody just do your thing. Step one, wake up early, gonna rise.
As you wake up in the morning, you want to find the latest, greatest information about criminal cases and have an intuitive conversation about the suspects associated with these cases. Head over to the Bullhorn Betty channel on YouTube. Breaking news right here on the Bullhorn Betty channel. Welcome to the Bullhorn Betty Coffee Club. Enjoy your stay and enjoy your day.
Good morning, YouTube. I am up early this morning, earlier than normal. So good morning to all. I hope you guys are doing amazing today. I'm not sure how long we'll stay on. Many of you guys don't know there is a hearing in the Gabby Petito case. Well, between the Brian Laundrie's parents and Gabby Petito's parents today in Sarasota. I will most likely be out front. It was asked, is anybody going to be showing up to these hearings? Is the Petito's going to be there, or and the Schmitz, or is the the Laundrie parents going to be there? I don't know. But what I can tell you is this is a motion hearing. And when I look at the docket, it's for the motion to dismiss. So I figured, well, maybe we should go over some of that information. But I will most likely around noon be going live from out front of the Sarasota County Courthouse. We will see who shows up today. But I have to think with the motion to dismiss, at least somebody is going to be there, And one of the questions I would like to ask is, if I get the opportunity, is why did you help your son? Why didn't you just do the right thing? Sometimes in life, you got to make some tough decisions, and you have to be right with those decisions and right with God, in my opinion. Maybe other people don't believe that. I do, I didn't come, my parents allowed me to walk through whatever I had to walk through. They didn't give me excuses. They didn't get involved. And these were for minor stuff. This is a major, major situation where, you had a violent son. I mean, the bottom line is many people don't know is that we were out in front of there. We got to speak to neighbors. We got to hear what happened inside that home before they even went on their trip around the country. And there's no way in my mind that those parents did not realize that this was a very volatile situation, that there was abuse happening at the hands of their son, and they did nothing, absolutely nothing to protect Gabby Petito, in my opinion. So I am wearing my Justice for Gabby shirt. This is the shirt I wore out in front of their home when I was out there. And I will be wearing it this morning to the court hearing. I'm not going to dress up. I'm going to have my press credentials on, but I'm not going to dress up. I'm wearing my Justice for Gabby shirt because to this day, I don't feel that that Gabby has ever had justice. I really don't. I think the Laundrie parents should have been charged with something. They got to walk scot-free. Their son got to take the easy way out. And there's still a whole side of the family that is just, that is just out there and doing nothing. They got no justice. Everybody's able to live their life. And we have Gabby, a beautiful soul, gone at the hands of one of their sons. And they actually helped their son try to get away with it. They actually helped their son try to get away with it. And that is just really, really, really sad. So, yeah, guys, we got, I don't know who's in here, but obviously they want some attention. So we'll see if that affects anything. I don't think it affects anything on my end, but who knows? Just get them out of here. And if it gets too much in here, then we'll just go ahead and change it over to subscriber mode. So we'll see what's going on. But anyways, good morning, all. I don't know. We have a lot of Summers Army that continues to do good work, but prior to Summers Army, there was Team Gabby. And this is a Team Gabby item, which I hope we listen to and, push far and wide. There's a lot of nuances with this case that bother me. And one of them was the response from the Laundrie parents, when they were arguing against it, and probably what's going to be in this motion to dismiss. We're gonna read through that here in just shortly. And again, I don't know how long this live is going to be. Excuse me. How long this live is going to be up, go for? I don't know. I gotta get I just don't know. I don't know. And I apologize for wiping my nose, but my allergies this time of year is just horrible. I was hoping when I was dealing with it a month ago that it'd be over soon, and it's not. So I guess this is going to be a long allergy weekend. Or allergy season. I don't know. So please excuse me. So the first one, Cool Gamer. Nice to see you. First to say hi in the chat. So good morning, Frankie Baby, Karen Davis, Sage, Terry, good morning. Karen Davis. Oh, I already said Karen Davis. What is this? Castor. I don't know, but good morning from Scotland. Good morning. Dream Girl Sarah, Tammy T. Good morning. Good morning. Good morning. And of course, we have a troll in here. So we'll say hi to the troll too. Good morning. Mama of 3. Oh, that's cute. Section 2, number 1. Good morning. Good morning, Michelle. Vintage Spider. Good morning. All crimes cases are solvable. Good morning. It's nice. Nice to see you here this morning. Moonlight Magic. Good morning. Good morning, all. I do appreciate you guys being here. So, again, I just wanted to go over this case. We were going to be, this motion to dismiss and their response. There was a response to the motion to dismiss that I want to cover this morning as well. But before we do, I want to turn this over to our beloved Language of Letting Go by Melody Beattie. For all those people that did not get the notification this morning, please check your notifications. Make sure the bell is fully filled in and selected to all. A big shout out to my ex today. I just realized was his birthday as I opened the book. So hopefully he's having a great birthday today. I don't know. So, but we'll give him a shout out anyways. So June 22nd is Relaxing is How We Heal. And I like that. Relaxing is how we heal. Stopping, calming, and resting are preconditions for healing. When animals in the forest are wounded, they find a place to lie down and rest completely for many days. They just rest. They get the healing they need. So that's an important part. And that's from Thich Nhat Hanh. I don't know who that is, but that's what was said. We hurt, we suffer, we wrong our loved ones, and they do wrong by us. Reaching desperately for answers will not help us. Pretending we're not hurt doesn't help us either. When we are wounded, the wound needs rest in order to heal. So it is with our souls. If we poke at our hurt, pick at our sore, rub it in the dirt of others' opinions, we do not allow it time to heal. If we've been hurt, accept that. Feel the hurt. Be aware of it. Let it heal. Maybe it would be better if you didn't talk to that person for a while. Maybe you need to let go of the relationship. Maybe you need some quiet time. Whatever the answer is, find a safe place and allow yourself to heal. If you're feeling pain, be aware of it. Feel the pain and then quit picking at the wound. Lie low, quit fighting, relax. Give your wounds time enough to rest, to heal. God help me relax enough to stop, calm down, and heal. I love that. I love that. So, good morning, all. So we're going to try to, it looks like we do have somebody in here. Guys, I may have to move this over to subscriber only for 5 hours. To get this person to leave the chat alone, but who knows? Hopefully we can move forward. Actually, let me just go ahead and do that. So for all the new subscribers, if you cannot write, I do apologize about that. If it's too much and I see some people in here that can't communicate, I will release that. But for right now, we're just going to enable subscriber only mode for right now. I'm not putting it on members mode. That's a good thing. So at least hopefully you guys can conversate. Good morning, Stormy. Good morning, Dream Girl Sarah. It is nice to see you guys in here this morning. Blue Jean Baby. Yes, coffee. I need coffee. I'm still not awake yet. Are you kidding me? Like, my alarm went off at like 5:30, and of course I've been telling you guys I have had a problem with the alarm, and I just snoozed it, but I couldn't go back to sleep, so I got up and started getting ready with my morning. And somebody had reached out to me asking me if I was going to go to the court hearing, and I'm like, yeah, I'm going to be there. I'll be out front there for a little bit. I don't know if I'll go inside. I may go inside for a little bit. We'll see. Once I get inside the courthouse, I can't use my phone. So I will have to wait until after the court hearing's over to come live again and tell you what had transpired inside the courtroom. At any rate, Jotzi, good morning. Terry, good morning. Emma Lou, I believe I said hi to you, Miss Karen Davis, but I'm not sure. I can't remember because I'm not awake, right? I'm just not awake this morning. I'm not awake. So we're going to go over this. We're going to talk about it, and then we're going to open the phone lines up and see what you guys think about it this morning. So I've already pulled it up, and this one here, there's my court hearing against him for the sign. Not too much when you look up, the Laundrie's never had any legal issues here in the state of Florida or in Sarasota County, at least, since they've been here. So good morning, Tennessee, Eastern Tennessee girl. Good morning. Will the case be streamed? I don't know if they're going to be streaming it online or not from the courthouse. I don't know. I just know that once we get in there, typically they don't allow us to set up even press. Usually they've already hired a camera person, and the press has to coordinate with the camera person to get those photos as part of being the Associated Press. And then usually they have their own videographer where you can request their footage. There's a process to go through in some cases. That doesn't necessarily mean that's going to happen in Sarasota. They may allow us to set up, but typically they don't allow a whole lot to set up in the courtrooms, especially if they're full. It's usually just one videographer and one photographer in there. So I'm not sure how Sarasota is going to handle it. I'll find out when I get there. I can't go back to sleep now. I might as well get dolled up for the day. That's it. But I didn't go. I brushed my teeth. I fixed my hair, but I didn't do a whole lot with my face. I'll do that when I start getting ready to go to the court hearing, which it will be as soon as we get done here on this live. So, but here's the court hearing. As you see, June 22nd, 1:30, courtroom D. This is for motions. It has not been canceled. It appears the one on the 5th was canceled, and it looks like the one on the 30th is canceled. So they're not through the process yet. And a lot of that is because we're in a motion to dismiss. They did not answer the complaint yet. They're trying to dismiss it before they answer it. And if you haven't answered the complaint yet, there's no point in having a case management conference on 6:30 because nothing has really moved in this case yet. They're still dealing with pretrial motions and things of that nature. Part of that pretrial motion is the motion to dismiss. So we've heard about the complaint that was levied against the Laundrie parents. And so we've also heard some of people's comments related to the motion to dismiss. So we're going to go through that, and we're going to go through the response to the motion to dismiss. So what is this? WFOIJB, he is apparently streaming live. Okay, so yeah, they probably are because they are a big organization. They probably have everything set up to either have their own camera crew in there that was approved, or they've already coordinated with the courthouse to have a live stream. So yeah, that would be good. So Petito family using their I've never heard that before. I would think it would be I don't know if that would be possible because she wasn't in their home. There's a lot of nuances as to where you can use homeowners insurance for. So I'd have to probably venture to say no, but I don't know for a fact. Yeah. Yes, don't forget to go out there and give me the thumbs up this morning. I don't anticipate this being a huge stream like we're accustomed to because we're talking about a different topic other than Summer Wells. But this is the case that I spent 5 weeks, pounds of sweat, pounds of tears, just worked so hard fighting for Gabby, fighting that her name and her face did not go out of the media. We did a very good job about keeping her face alive. So we just keep moving. Just listen to WFLA. Both sides will be in court today. Perfect. So both sides will be in court today. So hopefully I will get an opportunity to say hi and speak to somebody there. We'll see. We'll see what we can get. So just going into this is a 26-page document. So we're going to try to go through it fairly quickly, as quickly as we can. Not sure what all that. So it's just basically, this is the plaintiff's response to defendant's motion to dismiss. So let me go back into this court docket real quick. Motion to dismiss complaint. So this is the defendant's motion to dismiss. This is from the Laundries. They're going to be considered the Laundries for the purposes of these complaints. So let's just read it. So the facts surrounding the case have received widespread media attention, and the court is likely least generally aware of the events that preceded the filing of this lawsuit. The complaint alleges that the plaintiff's daughter, Gabby Petito, and the defendant's son, Brian Laundrie, were engaged to be married. Mrs. Petito and Mr. Laundrie were traveling the western United States in the summer of 2021. At some point during the trip, Ms. Petito went missing, and there was a search for her whereabouts. Shortly thereafter, law enforcement commenced an investigation which included Brian Laundrie and the defendants. The complaint does not allege when Ms. Petito was reported missing or when law enforcement investigation of the Laundries began, but news reports indicated Ms. Schmidt reported Ms. Petito missing in Suffolk County, New York Police Department on September 11, 2021. Ms. Petito was found deceased in Wyoming on September 19th. Laundrie was found deceased in Florida on October 20th of suspected suicide. Memorandum of law. This is kind of like a breakdown. What a memorandum is. It's just a breakdown of this law. So I'm just going to read this to you guys as well. The amended complaint should be dismissed with prejudice. So what does that mean? They're trying to dismiss this complaint with prejudice, which means they don't ever want them to be able to bring this court case back. So they want to be able to get this dismissed and the Schmidt and Petito family can never refile again. I don't know if the courts are going to be that harsh because it does sound like they do have some type of claim and some type of, that I believe a judge will allow to be heard at some point. So I'm not sure if they're going to be willing to go as far. I mean, with prejudice is a pretty harsh order. And I don't know if that rises to that level. We'll see, but I don't know if it'll rise to that level. So a motion to dismiss with prejudice, and the plaintiff should not be granted leave to amend. So they're really trying to, and you, when you're in a court hearing, especially a civil suit, leave to amend is not an uncommon strategy or need that goes into this. So they're really trying to get this thrown out forever. They don't want the Petitos ever coming back, the Schmidts and Petitos ever coming back and filing back against them. I don't know. That's some pretty strong language for a motion to dismiss. Just saying, pretty strong language. Shall be freely. So although leave of court to amend pleadings shall be freely when justice is so required. So they're acknowledging that, this is freely given, but under, the Florida Rules of Civil Procedure 1.190A, leave to amend need not to be given where an amendment is would be futile. But they still are trying to ask for that. A proposed amendment is futile if it is insufficiently pled or insufficient as a matter of law. The amended complaint is deficient as a matter of law for many reasons, and those deficiencies cannot be cured by any further amendment. That's their opinion. That's the defense's opinion. That does not necessarily mean that is accurate or true. The gravamen of claimed wrongdoing is that the Laundries exceeded their constitutional rights and essentially made no statement to the plaintiff or law enforcement. As a matter of law, the Laundries' silence conduct could not form a basis of a claim for intentional infliction of emotional distress. The Laundries' constitutional rights and the elements necessary for such cause of action would not change with any further amendment of the complaint. Further, the time period at issue occurred several months ago when the foundation of the plaintiff's claim claimed duress. Wanting to find their daughter has been resolved. So they're basically saying, yeah, so maybe you were under duress, but your daughter has been found. So, it doesn't change like some of this stuff. It is factual, but it just, what I don't like about it, I think what we're going to find out is that they actually have admitted, in my opinion, everything that the Petitos are claiming against them. But they're saying it's their constitutional right to have remained silent, and you can't come after them for that. I'm not sure if that's accurate or not, but that's what they're claiming. So, and then that kind of makes you almost sick to your stomach that they are actually acknowledging that they did this to the Petito family, and it's sad. The plaintiff's failures to state a cause of action in the amended complaint provides ample basis to conclude that the plaintiff would not be able to add the missing but required information if provided with yet another opportunity to bolster their allegations. As any additional amendments to the complaint would be futile, the amended complaint should be dismissed with prejudice. The complaint fails to state a cause of action for intentional infliction of emotional distress. The pleading must be something more than ingenious academic exercise in conceivable. I hate legalese, it sucks. Florida is fact pleading jurisdiction. To withstand dismissal, a plaintiff must allege more than naked legal conclusion. So they're basically saying that these people are just, trying to grasp at straws. I don't know if that's accurate or not, but that's what the defense is basically stating. It is insufficient to plead opinions, theory, legal conclusions, or argument. The quality of pleading that is acceptable in federal court and which will routinely survive motion to dismiss for failure to state a claim upon which relief may be granted will commonly not approach the minimum pleading threshold required by our state court. And so we're not going to go into all these. This is the case law. Remember when I'm talking about people read the statutes and they don't have the case law to explain the statutes. And we talk about this often on this channel. This right here is the case law. This is what defines those statutes that you read. So when people read statutes and they come out on YouTube and try to explain the law when they have no education in it, and they're reading a statute, but that's only half the job, right? You got to define that statute because what you're reading is not necessarily what that statute is saying. It depends upon the case law, which sets precedent. This is the case law. This is how it's written. This is what defines the statute. You very rarely in these pleadings ever see, well, according to Florida statute section 1.75E, subsection 2, subsection A, you never see that in court pleadings to argue a case. It's very rare. Do they put, Florida statutes in here? Yes, but it's always defined by case law. This is right here is what I'm talking about. So when people try to explain the law to you and they're just reading a Florida statute or a state statute, they're not explaining the law well, because the law is not explained until you start seeing your case law. This is case law. So when we go in here, we will read this case and find out what the order which defines that statute. And that's why you very rarely ever see statutes listed in a complaint. You always see the case law, because this case law is the defining work that defines that statute. It is what explains to the judge why the statute is read one way instead of another way, just for people that do not understand. Florida officially recognized the tort of intentional infliction of emotional distress in Metropolitan Life Insurance versus McCarson, which adopted Section 46, restated second of tort in 1965. To state a cause of action, a complaint must allege 4 elements. Remember that those prong tests I was just talking about? This is a 4-prong test that has to be stated in order to show a cause of action related to this intentional infliction of emotional distress. We always talk about these prong tests. You have to meet certain thresholds in order to have a cause of action. This is one of them right here. So we're going to read it. And this is a good example of what when I'm talking about these things and you don't understand, this is exactly what I'm talking about. So this would be a 4-prong test. And in this case, the 4 elements to be able to have the complaint of intentional infliction of emotional distress. And the first prong is deliberately or recklessly inflicting mental suffering. The other one is outrageous conduct. The conduct caused emotional distress. And the 4th one is the distress was severe. This can be used, and we're going to discuss this because these are the elements to argue intentional infliction of emotional distress. We're going to come back to this at on another topic related to the bullying here on YouTube, but I digress because that's off topic. We're going to stick on topic. Liberty Mutual Insurance and Stedman, this is more case law that helps define that statute related to intentional emotional distress. So it defines it. So the behavior claimed to constitute intentional infliction of emotional distress must be so outrageous in character and so extreme in a degree as it goes beyond all possible bounds of decency. And if you guys read that, the definition that's defined in one of these cases is so outrageous in character. Who defines so outrageous, right? This is kind of up for interpretation. It's up for interpretation as to what is so outrageous, what is considered so extreme in degree, and what is considered goes beyond all possible bounds of decency, right? So interesting stuff. In applying that standard, it's subjective. That's what I was trying to say. In applying the standard, the subjective response of the person who is target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. Rather, the court must evaluate the conduct as objectively as possible to determine whether it is. So it is, and it states right here that it's up to the courts to determine that. It's up to the courts to determine that. But they're saying that there's no elements here to argue this. And it sounds to me like there are some elements here that they could successfully argue this intentional emotional distress argument. Just based on, might be based on the information, because I've got information related to this case. I was out there every single day for well over 5 weeks. Even if the complaint alleges facts, those facts, if proved, must establish a cause of action for which relief may be granted. While the plaintiff alleges some facts, those facts could never establish a claim of intentional infliction of emotional distress because the Laundrie's actions were legally permissible, constitutionally protected, not outrageous, and do not give rise to any cause of action. So they're not denying the fact that they did the actions that they've done. The Laundries are not saying, we didn't do that. They're saying we're constitutionally protected to be able to act that way. And I'm not sure if that's the case. I don't know. You know, it's for the court of law to decide that. It's for the court of law. The Laundrie's inaction was not outrageous, but legally permissible and constitutionally protected. So outrageousness is the threshold test. Wrong test. It's a threshold test for recovery in an intentional infliction of emotional distress claim. Whether conduct is outrageous enough to support such a claim is a question of law, not a question of fact. Well, that's why they're at the court. Just saying. Importantly, the standard of outrageous conduct is particularly high in Florida. Patterson versus Downtown Medical and Diagnostic Center. Also citing another one, Golden versus Complete Holdings. Exhaustive or concrete list of what constitutes outrageous conduct. So let's reiterate this. While there's no exhaustive or concrete list of what constitutes outrageous conduct, Florida common law is evolved an extremely high standard. That's what they're alleging. It is not enough that the defendant acted with the intent, which is torturous, and that's tort. You know, it's not means like they're torturing, or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damage or other tort. Tort is something that happened to you. We'll look up that so I can give you the correct legal term for that. But tort, you have criminals and you have tort, criminal case and tort cases are civil cases. What else is in here? Let's just keep going. Although the amended complaint alleges that the Laundrie's conduct was outrageous, the plaintiff's failure to provide factual support rise to the level of outrageous conduct makes an allegation nothing more than a legal conclusion. I think they might have the elements. I'm not sure how you guys feel, but I think they might have the elements for some of this. The Petito family, you know, the Schmidt and Petito family, I think they have elements that can rise to the level. I don't know if all these counts will be sufficient, but I think that they will be successful in something that will allow them to move forward in the case. You know, they both have very high qualified attorneys, and I don't know if an attorney would have brought this without, because whenever you're reading case law, you have case law that supports your argument and case law that doesn't support your argument. And typically, you know, when depending on what side you're arguing, you're taking the case law that actually supports your argument, not necessarily what doesn't support your argument. Occasionally, you'll get an attorney that will actually argue both sides. They'll say, you know, although we have this case law that states this, there's this law that states this, but why we're relying on this particular case law that supports our argument is because this doesn't apply for whatever reason. And they'll explain all that in these pleadings. I'm not really seeing all that going on here, but there are in some cases where they do go ahead and argue both sides for the judge to get a full picture of what's going on. And with that not being done here, there may be a reason for that. I'm not sure. Conduct claim to cause severe emotional distress must be so outrageous in character and so extreme as it goes beyond all possible bounds of decency. And that's from, you know, Southern Second District ruling that came out. I don't know what year because I'm not pulling it up. The Laundrie's decision to exercise their constitutional rights to silence, privacy, and counsel, and to have their attorneys speak for them under such trying circumstances and media pressure could not be further from the conduct that is extreme or goes beyond all bounds of decency. I'm not not sure. I'm trying to think about this. The right to remain silent. How was the right to remain silent afforded to the parents when the parents weren't under, weren't the criminals, weren't the ones that they were looking for? They weren't under criminal. You know what I'm saying? It was their son that was. So I'm not. That might be the crux of the argument there, because I'm not sure. Their son had a right to remain silent. Their son had the, because the son was the one responsible for Gabby's death. He would have but I don't know if they weren't a participant. How are they able to plead? You can't plead the fifth in civil cases. You can't plead the fifth in civil cases. So I'm not sure. People would and should do in such situations. The letter by the plaintiff's attorney referenced in the amended complaint even acknowledges the complicated conditions faced by the Laundries. We understand we are going through a difficult time, and your instinct to protect your son is strong. The plaintiff cannot express sympathy and understanding for the Laundries' unenviable position, and then claim the Laundries caused them emotional distress by not responding in the way the plaintiffs desired. If the Laundries' acts of doing nothing other than maintaining their privacy and silence is enough to subject them to this supposed cause of action, then there would be virtually no limitations on torts of intentional infliction of emotional distress, and other fundamental rights to remain silent under any circumstances would be obliterated. And my question was, I never quite understood why the Laundrie parents were also, Bertolino should have been for their son, but he wasn't hired just for his son. Bertolino was protecting mom, dad, and the son, and it makes you wonder why. Why would the parents need to have a defense attorney protecting them when they did nothing wrong? Why were they all? We heard that from Cassie Laundrie, that everybody had an attorney but her, and she felt like they were throwing her under the bus. I don't know if Cassie will be there. I have no idea. I know Bullhorn Betty will be there. So I'm not sure. Christopher Roberta Laundrie is asking for help in locating. Here. The only attempt at contact alleges that the attorney for the plaintiffs issued a letter to Christopher asking for help in locating Miss Petito. So not only did the parents call them, and now mind you, I want to paint this picture for everybody in here. I really do. I want to paint this picture for everybody in here. I'm going to go ahead and take this off subscriber mode. I'm hoping that we have the trolls taken care of. It looks like some people that came here to talk may not be able to talk because they just subscribed or something like that. So I'm going to go ahead and take that off here real quick, so everybody can have an open communication. Sometimes we have to do that because the trolls come in here and just disrupt, which I think something needs to be done. There should, in my opinion, YouTube should have stuff in here that we can stop these people from doing that. But I digress. We are working on it. It's a working process every day. I feel like we're moving the needle in the right direction on that front, just to let everybody know. But that's been taken off, hopefully. So for my mods, if anything's outrageous, just block them. If anybody is rude to other creators in here, you are to give them a warning. And we'll, remove their comments. But if it's egregious, I want them blocked. But if it's not egregious, then don't block them. Because it would violate the rule 4-4.2 of the rules regulating the Florida bar for plaintiff's attorney to contact the Laundries, knowing the Laundries were represented by attorney at the time. The plaintiff's attorney presumably did not send that letter directly to the Laundries and the amended complaint is not specific on how the letter was issued, whether through the mail or some other means. The amended complaint says nothing about whether the Laundries actually received the letter, so their lack of response is a far cry. Let me go back over here. Far cry from outrageous conduct. I'm sorry, but many people don't know that the Laundrie parents. Now, mind you, I want to paint a picture for you, which I was just about to do. I want to paint a picture for you. You have a child. Your child decides to go live with her boyfriend in their parents' home, his parents' home. You're entrusting your child, whether they're adult or not, whether they meet that legal 18-year threshold or not, it does not matter. You're trusting the boyfriend and the parents with the most precious thing that you have, your child, right? You're trusting that they're going to protect your child, that they're going to do right by your child. And something happens. And you, as the in-laws, because these kids were engaged to be married, you as the in-laws, you're calling your in-laws to find out where the kids are. You haven't heard from the kids. How is it not disgusting from your in-laws not only to hang up the phone on you multiple times, but then to block your calls while you're frantically looking for your child? Not that we're remaining silent, we're going to let the law enforcement and attorneys take care of it. They didn't tell them that. They didn't tell them that. They just hung up the phone on them, refused to answer the door, and blocked their calls. How is that not disgusting and deplorable? How is that not disgusting and deplorable? Now, mind you, these parents had no idea that all this stuff was going on in that house, but you know who did? The dirty laundry parents. The dirty laundry parents knew what went on under their roof before those kids went on the road. They knew. We walked around that neighborhood and people said there was a lot of yelling and screaming from that house before they went on their trip. When we heard from people that have actually been inside that house, remember we kept saying, how are these people not able to leave their home? Like they didn't leave their home for weeks on end, not to get groceries or anything. We heard that that house is stocked like doomsday. So these parents are already weird. They think that the world's going to come to the end. They have that house stocked to the hilts with everything. And this is before this whole dynamic happened. Doomsday stocking of the Laundrie home. So not only were the parents a little, they taught that to their children. Because I'm telling you, you come in this house, you don't see me stocked for, with stuff that you could eat for months on end here. You don't see that. In their house, that's the way it is. They're the doomsday type of parents. Who knows? They may have a bunker. People were talking about that ant coming out of the yard. That's the kind of people these are. You never know. Seriously. That's conjecture. But still, you never know. Indeed, the slippery slope of allowing a cause of action to proceed would require anyone with knowledge of events that are hurtful or which cause emotional distress to another to convey their knowledge or to be exposed to liability. You're held responsible in the United States for your actions. If it's not criminally, you can be held accountable civilly. That's kind of how it works. The underlying events of crime itself committed by another may be outrageous, but declining to speak or communicate about it is not. Gabby Petito's death is undoubtedly tragic and her parents deserve sympathy. But the Laundries never gave them sympathy or empathy or compassion. They didn't do that because they're despicable people. Despicable. They didn't give them sympathy, empathy, or compassion. They didn't give a damn about Gabby. They didn't give a damn about what their son did. They didn't even go look for their own kid when they didn't know whether he was dead or alive. These parents have ice in their veins. They are disgusting people. Disgusting people with something wrong up in the noggin. So, however, a parent's grief caused by the disappearance and ultimate loss of a child does not create a cause of action against everyone who may or may not have had information about that child's disappearance or death. You're right. But when the parents lie, which they lied, we know for a fact Chris was out there in that van helping his son after he returned home. So if they knew that Gabby was dead, why is Chris's ass out there in that van helping him with something? The neighbor said it was cleaning, but I don't know. Was it cleaning the van? I don't know. I don't know. I don't know. Even if the courts were to have reservations as to whether the Laundrie's silence was outrageous, to permit this claim to move forward would trample the Laundrie's constitutional rights. Would it? If they didn't commit the crime, what gives them the right to remain silent? Remaining silent is the Fifth Amendment is so that you do not incriminate yourself. It is a protection so you're not incriminating yourself, the right to remain silent. The Fifth Amendment. So I'm not sure, because in civil cases, you don't get an opportunity to remain silent. You don't get the constitutional benefit of pleading the Fifth. Only in criminal cases. Would that apply here? Is the question. Would somebody that's not under criminal investigation apply here? I think that might be the argument. As discussed below, the Laundrie's conduct was legally protected and cannot form a basis of an intentional infliction of emotional distress claim. I don't know. Because listen, guys, we have a First Amendment right? To speak freely. But when that goes to harassment, you violate it. You don't get that First Amendment privilege, and that's a constitutional right to speak freely. The same thing here applies. How can you say that you're going to remain silent in a criminal plead the Fifth when you're not under criminal investigation? When the parents are calling you, you're not under criminal investigation. Your son is. And not only that, but apparently they were calling before their son ever made it back to the state of Florida. So before there was ever even a criminal investigation, I'm not sure. I'm not sure about this. This is interesting. This will be interesting. This will be interesting to hear argued. I will tell you that. However, compelling individuals to respond to inquiries by private citizens or law enforcement through a civil action like this would turn our entire constitutional system and freedoms afforded to individuals in this country on its head. I don't believe that. Cases like this are brought forward all the time, successfully. So I'm not sure. The plaintiff's suit, founded on their thoughts or positions on what they wanted the Laundries to do, infringes on too many fundamental rights to all discussed in this motion. But The exercise of even one right is sufficient to defeat the claim of intentional infliction of emotional distress. I don't know if that's true. I don't know if that's true. So we see that they don't want people. They don't want this infliction of emotional distress. It seems like the majority of this is related to the emotional distress allegation. I'm curious to see the response. Plaintiffs have not alleged facts supporting causation. To state claim of intentional infliction of emotional distress, a complaint must put forth factual supported allegations that the defendant's outrageous conduct was caused the defendant's emotional distress. Now, I'm sorry, but them having to prove. I understand they have to prove it, but in my mind, watching this stuff unfold in real life, to me, was emotional. It was emotional distress upon me to have watched it. I can't imagine being the parents of Gabby Petito. Period. As parents would be, the plaintiffs were distraught about their daughter's whereabouts. The Laundries did not cause Gabby Petito to go missing or the plaintiff's reaction to that news. The amended complaint alleges that the Laundries could prevent such additional mental suffering and anguish of Joseph Petito and Nicole Schmidt by disclosing what they knew about the well-being and the location of the remains of Gabby Petito. They could have done that. They could have been decent people and did that. They already knew their son killed her. They already knew that their son was a murderer. Why did they not do anything to console their in-laws? I can't imagine if I had a child and my child caused such pain to another family. But I'm not one of those parents that are going to protect my child. I'm not. I would never do that. I would never stick my neck out there like that. I would love my children. My mom loves me, but my mom allowed me to walk what I had to walk through. My dad allowed me to walk through what I had to walk through. Were they there supporting me and helping me get through it? Yes, they were. But no way and shape did they condone or support when I was doing wrong. That's just not how I was raised. It's just not. And I can't imagine my child taking somebody else's life. I would be there holding their hand and getting them, that part I would do, getting my kid an attorney and telling him to keep his mouth shut. But I don't know if I wouldn't have tried to help find the victim, help be part of that. I don't know if my first thought would be to go on vacation and go on a camping trip when my daughter-in-law, my soon-to-be daughter-in-law, is missing. I don't know if I'm that heartless. I don't know if I have that in me. I don't. I would have marched him to the police station ASAP. Me too. Me too. Absolutely. People try to say that I don't know what I'm talking about because I don't have children. I did. I had stepkids. I had grandchildren. Doesn't change the fact that there's right and there's a right way to do things and a wrong way to do things. But I'm curious to find out if that right to remain silent, that Fifth Amendment, applied to the Laundries if they weren't under investigation. Good morning. Dolly Vision is in the house. Nice to see you. Nice to see you. But I do believe their conduct was outrageous. Does that mean it passes the legal standard of outrageous? No. I'm curious to find out. That's why I'm going to the court today. I want to hear this argued. I really would like to hear this argued. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produce and contributed to substantially to producing such severe emotional distress so that it can reasonably be said that, but legally, I'm telling you, I used to type this shit, excuse my language, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. So I'm curious about this conclusion. Let's read the conclusion. The plaintiffs have not and cannot set forth factual assertions that can be supported by evidence which gives rise to legal liability. I'm not sure if that's true, but that's what the defense is alleging. As such, the action of intentional infliction of emotional distress against the parents of Brian Laundrie, however artfully drafted, is not legally sustainable, and the amended complaint should be dismissed with prejudice, which, like I said, is pretty extreme, and without leave to amend for reasons set forth above. I don't know if any judge is going to, just in my opinion, is going to be that strong on an order to dismiss with prejudice and not allow the plaintiffs to leave, which is freely given, to amend their complaint. So I'm curious as to how this is going to end up playing out. But here's the plaintiff's response. And I'm interested in this. So what happened is the plaintiff filed a complaint in the courthouse, and the defense filed a motion to dismiss and set forth, and that's what we were just reading. Now, the plaintiffs have actually responded to that motion to dismiss. So let's see what they have to say in argument of that 26 page. This one was the 21 page. So they actually did a 26 page arguing against the 21 page motion to dismiss. And they're stating some stuff, general stuff here. Let's just get down to the motion to dismiss standard. So here it is. A motion to dismiss is designed to test the legal sufficiency of the complaint. In determining the merits of a motion to dismiss, the trial court must limit itself to the four corners of the complaint, and that's true. When you file a complaint, until it is brought to trial, the judge is required. They're not allowed to go outside of those four corners of the complaint. And what does that mean? You'll have to determine that by the case law there. But basically what that means is they have to take that complaint as true. Everything in that complaint is factual and true. And if they take everything in that complaint as factual and true, does it rise to the level of being able to successfully be argued? If the answer is yes, it must move forward. So a complaint should not be dismissed for failure to state cause of action unless it appears beyond doubt that the plaintiff would prove no set of facts that would entitle him to relief. And that is true. And the bottom line is they are entitled to some sort of relief, in my opinion. They are entitled to that. The function of the motion to dismiss a complaint is to raise as a question of legal sufficiency of the facts alleged in the cause of the state, to state a cause of action. For the purpose of passing upon a motion to dismiss, the court must assume all facts alleged in the complaint to be true. They have to. That's part of the law. That's how the process works. Consequently, a motion to dismiss a complaint must be decided on questions of law and questions of law only. So to me, it sounds like they're, and it's sad because I think the defendant's attorney jumped the gun a little bit because he basically, for the love of God, get out of my chat. Swear to God. I'm moving it back to subscriber only. I'm sorry, guys. I have no choice but to. I can't, and I'm just gonna keep it on there because it's just driving me nuts seeing these people in this chat. Give me just a second. Irritating. Adults that act like children. All right, mods, that should help you out. Hopefully, it'll help you out. I just changed this for subscriber only mode. Can you believe these people are adults? People are adults acting like children in this chat. It's irritating. And you wonder why we have a problem in our society is because it's people like that that are raising children. Just saying. Anyways, I digress. So the defendants, despite knowing that motion to dismiss concerns only what is contained within the four corners of a complaint, have taken great liberty in their motion to dismiss and stated as fact various matters outside of the record. So they're addressing that they are actually bringing more into the motion to dismiss than what is within the four corners of the complaint. And when you have a complaint, again, the courts must take everything in that complaint as true. So Metropolitan Life Company versus McCarson, the Supreme Court held that Florida recognizes the tort of an intentional infliction of emotional distress as defined and in Section 46 restated second of torts in 1965. The state's cause of action for intentional infliction of emotional distress, a complaint must allege four elements. This is the four-pronged test. And like I said, there's these types of prong tests in just about every argument that you have. So you need to find that. These are the things that the Florida statutes or the statutes of different states do not define for you. You can only get this defined by case law, which nobody across YouTube ever brings in the case law. They go, the Google attorneys on YouTube go to the statute, and then they go on here and they read you the statute and argue the statute when they have no idea what the hell they're talking about because they're not looking at the case law, which defines that statute, that sets precedent for what that statute means. And it's hilarious to me that people believe the crap that comes out of their mouths as truth when they don't even know what they're talking about and never once had one iota of education in the law. So this is the four-pronged test: deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused severe emotional distress, and the distress was severe. It is, in my opinion, this is subjective. Deliberate or reckless infliction of mental suffering, right? Liability for outrageous conduct was caused of severe emotional distress and arise when a wrongdoer desires to inflict severe emotional distress. When the wrongdoer knows that the severe emotional distress is certain or substantially certain to have results from his conduct, or when the wrongdoer acts recklessly in deliberate regard, a high degree of probability that the emotional distress will follow, and puts the case law there. To satisfy the first requirement of deliberate or reckless infliction of emotional suffering, plaintiff directs the court to the following paragraph of the amended complaint. It is believed that on August 27, 2021, Brian Laundrie murdered Gabby Petito. The cause of her death was blunt force injuries to the head and neck with manual strangulation. It is believed that therefore averred, if I pronounce that right, that on or about August 28, 2021, Brian Laundrie advised his parents, so the very next day, or it could have happened at night and went over to 12 o'clock in the morning. Either way, we don't know the facts about that. But the next day, it is alleged, August 28, 2021, Brian Laundrie advised his parents, Christopher and Roberta, that he had murdered Gabby Petito. On that same date, Christopher Laundrie and Roberta Laundrie spoke with an attorney, Steve Bertolino, and sent him a retainer on September 2nd, 2021. And you know what, guys? We said this out in front of their house. We knew that they knew about Gabby Petito before they hired this attorney. We asked them on the megaphones out in front of their house, when did they get that attorney? People didn't realize we had a good handle and a good understanding on what transpired and what took place. And this, the Laundries have never come out and said this is untrue. They are saying that they're within their rights to have this conduct. So everything that we had stated about the Laundrie parents is true. Their argument is it was within their rights to do so. That's their argument. Not that they didn't do it, folks. Not that they didn't do this stuff. Not that they weren't complicit, that they had a right to do so. That's their argument. After this point in time, there is no contact between Joseph Petito and Nicole Schmidt on the one hand, and Christopher Laundrie and Roberta Laundrie on the other. From August 22nd until September 19th, when Gabby Petito's remains were found at Spread Creek dispersed camping area in Wyoming, plaintiffs were extremely distraught and were attempting to locate Gabrielle Petito. While Gabrielle Petito's family was suffering, the Laundries went on vacation. Yes, folks, we all know that. We went out there to Fort DeSoto, went on vacation to Fort DeSoto from September 6 to September 7, 2021. They went on vacation knowing Brian Laundrie murdered Gabby Petito. It is believed that they knew where her body was located and further knew that Gabby Petito's parents were attempting to locate her. In an effort to avoid any contact with Nicole, on or around September 7th, Roberta blocked Nicole Schmidt on her cellular phone, such that neither phone could call or text could be delivered, and she blocked her on Facebook. So your kid did this despicable act, and you go and block the entire family because you just can't say your child was wrong and you're really sorry. You know what? The Petitos never got an apology ever from the Laundries. Like, I'm sorry we had to do this. We needed to protect our son. I'm sorry to hear about your daughter. I don't even know if they got Gabby's stuff out of their home. I have no idea. I don't know if I could be this heartless. I really don't. I mean, our children, we fight tooth and nail for our kids to do the right thing. We raise them and teach them right. But at some point, we got to quit protecting them. And I never understood this. And I don't understand parents, and I don't understand parents around the world that protect their children from this. I would want to protect them so they have a fair trial and things like that. But I don't know to what level that would go for me. I really don't. I really don't. I can't imagine my parents doing this. If the shoe was on the other foot, I can't imagine my parents. I have to imagine my mom would be crying and would be over at the in-laws' house, hugging them and apologizing and saying, I know you're probably angry with me, but I didn't know my kid would do this. I'm sorry. I don't know. I really don't. I guess you really don't know what you're capable of doing until you're put in the situation, in all fairness, right? I'm saying this right now, but how do I know? I haven't had to face this. I would hope that I would do the right thing all the time, whether it's a hard right decision or not. Easy right decisions are easy to do. Hard right decisions are hard to do. You have to dig deep to get that. I'm still curious about where the $20,000 came from. The parents moved that money over into his account to help him flee. To me, that's a criminal act. I don't know what the criminal standard is for that. For the Laundries to express their hope that Gabby was located and reunited with her family at a time when they knew she had been murdered by their son was beyond outrageous, and I have to agree. On September 16th, attorney Richard Stafford, on behalf of Gabby Petito's family, issued a letter to Christopher and Roberta Laundrie, and as follows. We are writing this letter to you to ask you for help to find our beautiful daughter. We understand you are going through a difficult time, and your instinct to protect your son is strong. We ask you to put yourself in our shoes. We haven't been able to sleep or eat, and our lives are falling apart. We believe you know the location of where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how can you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family have any decency left, please tell us where Gabby is located. Tell us if we're even looking in the right place. All we want is Gabby to come home. Please help us make this happen. That is heartbreaking. That is freaking heartbreaking. Absolutely heartbreaking. Despite the fact that Joseph Petito and Nicole Schmidt implored Christopher Laundrie and Roberta Laundrie to tell them if their daughter was alive, and if she was not, where her remains were located, Christopher and Roberta Laundrie refused to respond to either Joseph or Nicole Schmidt. The deliberate and reckless infliction of mental suffering on part of the defendants include their conduct in refusing to speak to the plaintiffs when they knew full well Gabby had been murdered by their son, that they knew where the body was, that they deliberately took efforts to block the ability of the plaintiffs to contact them, that they went on vacation with their son, who murdered the plaintiff's daughter, while the plaintiffs were desperately seeking any information they could find concerning the well-being and the whereabouts of their daughter, and that they issued a statement through their attorney that they hoped the search for Petito was successful and she was reunited with her family, all the time knowing that their son had murdered Gabby Petito and hid the body. I don't know. That's a pretty strong argument about how indecent and disgusting the Laundrie parents were. Just my opinion. I have a funny feeling they're going to be going to trial on this. I don't see this being dismissed with prejudice. I just don't. I really don't. The defendants affirmatively chose to withhold information from the plaintiffs, if not with the desire to inflict severe emotional distress, then certainly with the knowledge that severe emotional distress was certain or substantially certain to result from withholding the information. And at the very least, they acted recklessly in deliberate regard of a high degree of probability that the emotional distress would follow. I think the Petitos have outlined, the Petitos and Schmidt have outlined and crafted their arguments beautifully. Let's hope that it is successful today. We will see. I'm going to be there. I will be out in I will be in Sarasota County. I will be at this hearing. I'm going to be out. I'm going to go ahead inside and place my stuff there so I have my seat held. And I'm going to go outside. And I just want to know how they could do this to another human being. Mama Bear wants to protect her cub. To what end? To what end? They created the monster. They did that. People are saying, well, the parents can't be responsible. When you have a bunker in your own house, I'm not going to say a bunker, but they're living like the doomsday. They're doomsday parents. That is what was described to me. Doomsday parents. And that explains why they were able to hunker down in their home for a solid month without even going out for a gallon of milk. We kept wondering, how can they stay inside of one house for so long? Because they're doomsday parents. And I know there's a lot of people out there that are doomsday people. I'm not one of them. Really not. I don't stock my house like the world's going to come to an end. The world comes to an end, guess what? Bullworm Betty's screwed. Just don't live like that. Never have. I have faith. I wonder what else. Yeah, guns. I wonder what else is in there. But I never understood. It wasn't until it was described, what was described to me from inside their home. They're doomsday parents. They probably pushed that psychological garbage on their kid. I mean, the kid was messed up. It always made me wonder what kind of violence, kids are taught this stuff. You don't just have a loving, sweet family and one person is violent and nobody does anything about it. It seems to me like it's a top behavior. Who's violent in that home? Was Roberta violent to Christopher? Or was Christopher violent to Roberta? Or were they both violent to each other? These kids had to experience something. You just don't, it's a top behavior to have outbursts like that. I just don't believe that Brian is alone in this. I'm sorry, I don't. Something happened that was taught to him like that. There was a reason why that behavior was acceptable when he was perpetrating it on Gabby while in that home. No, you can't. But here's what, Graham, here's the issue here. The issue here is the fact that they lived in this home. We walked around. There was a lot of screams that came from that home, violent screams that came from that home prior to them ever going on the road. Those parents knew that their son was abusing Gabby and did nothing about it. She lived there for over a year before they went on the road. They knew that they were having these heated and violent outbursts, and the parents, swept it under the rug. I don't know how I feel about that. You can't blame your children. You can't blame the parents for the child's crime, but here the parents got themselves into it, in my opinion. I'm not sure, maybe you disagree with me, Graham. I'm not sure. I don't know if I could knowingly protect a child that took another person's life. I don't know if I could do that. I would protect them in a sense of getting them getting them the attorney and telling them to keep their freaking mouth shut. But I don't know if I could be that heartless, not to want to wrap my arms around the other family that my son or child hurt. I don't know if I could be that heartless. I mean, I would just, to me, I would almost want to go and console them and distraught because of what my child did. Some parents are different. Some parents want to protect their children to no end. But that's enabling the kid. And not only that, if they would have called the cops when he was beating the crap out of Gabby while they were in the house, maybe it would never have gotten to this point. But they never helped that girl. They never protected that girl. They never even protected their son, to be honest with you. All they cared about was themselves in all of this, in my opinion. I know. Hey, Graham, you're speaking to the choir here. My parents weren't responsible for my actions. I was a piece of shit for a really long time. I get what you're saying. I get it. I get it. My parents weren't responsible for I had at some point, no matter where you come from, you have to make a decision. Is this the path you want to go down? For a long time, I chose to go down this horrible path because of the stuff that happened to me that was traumatic to me as a child. Okay. Primarily, there was a lot of violence in my home. And was it all the time, consistent, nonstop? No, but there was definitely an alcoholic, part in my family. There was violence in my family. I saw really bad things go on in my house. Okay. And it scarred me. It scarred me for life. It pales into comparison to other people. But just because other people had worse things doesn't mean that what happened to me didn't affect me negatively. And I had outbursts as a kid. I ran away from home. I wanted attention. Any way I could get attention, I'd get attention, whether it was through bad means. My parents weren't responsible for my actions. I was old enough to know better and chose to let the things that were bothering me bother me in such a way that I acted out. And I continued to act out well into my adulthood. Did some things. Many of you guys know I have a DUI. What happens if I would have killed somebody right? What would have happened if I had gone out there and took a life? It's sad to think about that reality, but how would my parents react? Until you're in that situation, who knows? But I'd have to believe. Well, one, I have to believe my parents would have gotten me an attorney to help, protect me. But I don't see them enabling me, condoning me, or assisting me in the crime. I just don't. I don't. Yeah. Unfortunately, there's a lot. I mean, he was an adult, but I mean, if we look at it a different way, if he was an adult, parents are responsible for their children. If he was underage, they would absolutely be responsible for that child. He was lucky. He was a little older. He was an adult. But does that Fifth Amendment right to remain silent extend to his parents? That's the question. Yeah. Frankie Baby said, first of all, no parent in their right mind would let their children who was suffering a loss and grieving a loss, said, as the lawyer said, the parents let their son leave with a gun. Exactly. Exactly. And it always made me wonder, did they have that coming to Jesus conversation with their son? Or did he just decide to do it? Did they say, no, son, you're going to be, you're probably going to do some time over this. Maybe you need to make right with God. I've always wondered that. I've always wondered that. Not quite sure about this. Not always. I had abusive home, but wasn't abusive to my kids. Well, most people that come from an abusive home probably aren't abusive to their children. There's a lot of people that are. It's a mixed bag there. Some people go one way, some people go another way. For example, I talk about the childhood trauma my dad experienced. His parents walked away from him. He was in foster care. They were alcoholics. They couldn't get the kids back. My dad would be home by himself alone for days on end and have to hide from Child Protective Services in their house. One day they found them all and drug them out. Very traumatic experience for my father. And my father swore he would never leave his children like his parents did him. However, half of his brothers were not very good to their children. Out of the 6 siblings, 3 kept their kids and had successful lives, and 3 were just as bad as his parents were. So, 50-50. Maybe that's the number. I don't know. My dad raised us until we were 18. Since then, he's basically hasn't talked to me very often, but And when I talk about my dad and the pain that comes along with my dad, can you believe some creators out there pick that up and exploit that? The fact that I have pain over my father, that pales beyond decency. They have to expect extreme duress to come of that, but they don't care. Just saying. Let's see, let's go up here and read this. So, to satisfy the requirements that the conduct was outrageous, it also must be outrageous in character and so extreme in a degree to go beyond all possible bounds of decency, which I think has. But again, I'm not a judge. In applying that standard, it is manifest that the subjective response of the person who is the target of the actor's conduct, is not in control, is not to control the question of whether the tort occurred, rather an evaluation of the claimed misconduct must be taken to determine, as objective as is possible, whether it was atrocious and utterly intolerable in a civilized community. That burden falls on the judiciary. It is a matter of law, not a question of fact. So they're saying that, that needs to be determined. The only place to determine whether this was an infliction of emotional distress is the law, is the judge, is taking this to trial. They're the only ones that can decide this. So I think there is actually some good. I think this is the complaint itself has merit. To what degree, I don't know. That's only for a judge to decide. But I do believe it has merit. I do believe there is a portion, if not all, that is going to go forward to trial. Because again, at this stage, everything in that complaint must be considered true in the eyes of the court. And it is up to, and this is where the trial and the pretrial pleadings, motions, discovery, all that stuff comes into play. I hope that this is shot down. I hope the motion to dismiss is denied. I hope that the defense is finally required to answer the complaint. And I hope that the pretrial discovery is underway. This is where they're going to be asking for, phone records. They're going to be asking for, they're wanting to get a calendar of what happened, what transpired every second of every minute from the time that they knew that their daughter or their son had killed Gabby up to the current time. They want to know what in the world happened. And I think they have the right to do so. So without further ado, I am going to pull up the phones, and I want to hear what your thoughts are on this. How do you feel? Gabby Petito is very near and dear to my heart, as many of you guys know. It's how many of you guys knew who I was. Many of you guys did not know who Andrew was until the Gabby Petito case happened. So what do you feel? This is what I'd like to know. How did this case, one, make you feel? And what do you think is going to happen today? I will be there, folks. I'm going to be there. I will report back to you. Again, may not be able to go live inside the courthouse, may not be able to speak until after everything is wrapped up, but I will be there. I will be there. Phones are open, folks. Call in. Let me know your thoughts. I don't know if it was the left eye area. I have to look at the reports, Gail. To be honest with you, after this case was over and we went on to Kylen Schulte and Crystal Turner because we were curious if he had a hand in that, which he did not. And we were able to determine early on when we got into Utah that he wasn't responsible for theirs, but he stayed on the list. He just moved to the bottom of the list. And, we're just, I don't know. I feel bad. I feel bad for the Petito family. I never, after I found out who the Laundrie parents were, now mind you, there's no background for these parents. This is just information that I was able to obtain from their neighbors. And I can tell you, a lot of the neighbors in that community do not like them. They want them to move on. You got to remember, the people in that neighborhood saw Gabby Petito. Brian, it sounds like, has had problems. He was just a rotten guy for a really long time. This is not new information. I think that the only commonality that in it possibly, I'm not living their lives. Just want to make sure people know that. It's my assumption. But I believe the only thing that Gabby and Brian had in common, because Gabby was outgoing, she was she loved people, she loved being out, she loved, all this stuff, and it was Brian that was the introvert. Brian that didn't like being around other people. Brian that always, was always watching her from a far distance. She was always yearning for the affection in public and all this other stuff, where he didn't really do all that. And to me, it sounded like the only thing that they had together was the art. They both loved art. And I don't know if they really had any other commonality, because it sounded like he was very possessive. When we talked to the people that worked with him at Publix, he always talked about my. It's very possessive language. This is Betty.
Yes, this is Tammy Harrower.
Hey, Tammy.
I met you when you were doing the laundries.
Oh, very good, very good. What do you think about this case?
I think it's messed up.
Yeah,
I really do. I mean, I feel sorry for Gabby's parents, and then there's another couple that should be in jail, and they're not.
yeah. And we were out there fighting. We even told them, just tell us where. At first it was tell us where Gabby is. And when we got on the scene, it was September 17th was when they had all those people in there. I was not out in the front yard for that very first, when the cops first came there, when they reported their son missing. I was not there. It was my birthday that day, and I was actually in Fort Myers. I actually arrived on ground and was there September 18th and on. So I was there when her body was found, in Florida. I was in front of the Petito,
Right.
or the Laundrie house when they found her. And then we started saying, just tell us where Brian is. Tell us where Brian, they would not, we even told them, we'll leave. Just start cooperating with law enforcement. We'll leave. We don't want to be here. It's hot, 100
Exactly.
degrees out there. I had better things to be doing with my time.
Right. Yeah, it's just another Candace.
Yeah.
And that's all it reminds me of. My chat's not coming out, so I've been writing you on this, but for some reason, my words are not coming up.
Oh, you're not able to communicate? Are you a subscriber? I enabled subscriber mode. So if you're not a subscriber to the channel, it won't let you write. You got to be a subscriber for at least 5 hours. Are you a subscriber to the channel?
Yeah, I've been since the beginning, since Petito.
Okay. Well, I'm wondering what's going on with that. I'll have to send me the link. Send me your handle, your YouTube handle, and I'll check and make sure you're not blocked on my end somewhere.
Okay.
Okay.
Yeah, keep up the good job. I love you.
Oh,
You're
thank
awesome.
you. Thank you. Love you too. You guys take care. And
You
we'll
too.
chat soon.
Okay.
All right. Bye-bye. So tell me what your thoughts are. How do you feel about this? How do you feel about this case? Do you think that the Laundrie parents have any need to worry? Did they do something wrong? Did they intentionally inflict the emotional distress upon the Petito family? Well, it's kind of hard when you live with your parents and your parents are always home, like Brian Laundrie's parents were home, how they could not have heard the screams coming from those bedrooms when the neighbors could. I see this is an assumption that you're manufacturing. So just to let you know, there's a lot of neighbors that live in and around their house that we talk to. And to me, there's no way that these parents couldn't have known what was going on in the house because they were home. It's kind of hard to say that, somebody 3 doors down can hear the screams from their home, but the people sitting in the living room can't. Just my opinion. I could be wrong. Maybe they really can't hear. I don't know. They could hear me. Betty. Hello.
Hello.
Hey, this is Betty. How can I help you? Can you hear me? Okay, well, try to call back. Try to call back. Sorry you couldn't hear me. So, I mean, I understand your point, Central Florida mommies. I do understand your point. But, yeah. But can you imagine? I mean, you're a mommy. Can you imagine somebody going camping while you're desperately searching for your child? And not only that, but getting a letter pleading for you to tell them something. God, that's heartbreaking. It's absolutely heartbreaking. Yeah, I hope so. So what we can expect today, let's talk about what we're going to expect today. So today they're having a hearing on the motions. I looked at what motions they were going to be having a hearing on. It looks like it's the motion to dismiss. So this judge is going to either order that the complaint is not legally sufficient and dismiss it. They could dismiss a portion of the complaint. But it sounds to me like everything was directed to one cause of action, which is the intentional infliction of emotional distress. That's what all the arguments appear to be directed at. So the judge is going to determine whether the Petito Schmidt family has enough to move it forward to survive a motion to dismiss. Yes, time for changes. This is about the civil case that is against that the parents, Gabby's parents and Brian's parents, are now involved in. And so we're going there for a motions hearing. The only motions that appear to be on record right now on the docket, which I pulled, is the motion to dismiss. So if the judge says, sides with the defendants, then hopefully they do not dismiss this with prejudice. I don't know if a case like this, the judge would ever feel comfortable in dismissing this with prejudice because it just got started. And I don't foresee a judge saying you do not have any claim whatsoever to these parents. I don't know if a judge would be that harsh on the Petito family. What could happen is they could go in here and have a motion to dismiss. They will be forced to amend their complaint to find better arguments against the Laundrie family. The other side of this is the judge states that there's enough meat on the bone for them to survive the motion to dismiss. And now the motion to dismiss is denied. And now the Laundrie parents have to answer the complaint. And once that happens, now we have our pretrial motions that go in, our pretrial discovery. That's your production of documents, your notice of taking deposition, your interrogatories, your requests for admissions, and there's timelines that go with those things. So now comes the legal strategy on how to successfully try this case. So we've got a lot of stuff going on here, and today's going to be the ultimate factor as to whether this case moves forward, has to be amended, or is thrown out. We're about to find out today. I'm going to be cutting this off here. If anybody has any other things to say, because we're up on 2 hours, today's going to be a 2-hour live because of the simple fact that I've got to get dressed. I got to be prepared. I want to be able to make sure I have, because I can't wear belts. I can't, I don't want to go through all this huge process at this courthouse of having to, take just about everything I have on off. So, I got to make sure that my keys, I got to go in there with limited stuff. So, I hope they don't dismiss it either. I'm reading this with my knowledge of this type of case, and I have a funny feeling this might survive the motion to dismiss. I'm not willing to bet on it, but I am confident, at least of a high degree, that this is going to survive the motion to dismiss. I'm interested in hearing the arguments before the judge. We're seeing their arguments on paper, but I'm interested as to what the judge may say. What's going on here is we've got the defendants arguing that they had a right to do this, that it was within their constitutional right to stay silent. On the other end, we have the plaintiffs that are saying that no, this can't be dismissed. You have to believe us in the four corners of this document, that everything that's in this document is true. And if it's true, it meets the standard to move forward to trial. So we're about to see what happens here. And then there's one last document that I wanted to go. It's a smaller document. It's only 7 pages. And this is the response. So we had the complaint where the defendants did the motion to dismiss. Then the plaintiff responded to that motion to dismiss. And now we have the defense responding to the plaintiff's response to the motion to dismiss. So let's look at this real quick, and then we'll move on and start, powering down this live. So the defendant's reply in support of the motion to dismiss is amended. Plaintiffs raise a number of arguments in their response to the motion to dismiss, but at the end of the day, the gist of this action is that the plaintiffs want liability for the Laundrie's silence. The plaintiffs are unable to point to any case where liability for such has been found, nor any case establishing a duty to communicate or speak in these circumstances. There is no federal nor Florida Good Samaritan law or other legal requirement that compels the Laundries to communicate or speak, and which would supersede the right of every person to remain silent. I don't know if I necessarily agree with that. In paragraph 18 on page 9 of the response, plaintiffs cite a case as an example of conduct found sufficiently outrageous to the level to survive dismissal. What these cases have in common is that the defendants therein committed an affirmative act directed at the plaintiff. So they're basically saying these people did nothing to the plaintiff. It wasn't them, it was their son. None of these cases found an action based entirely on a defendant's inaction. Plaintiffs cite no such case, and counsel for the Laundries has likewise been unable to find any. Remaining silent and having no contact with the plaintiff, regardless of the circumstances, is not what Florida law considers outrageous behavior. That's their determination. That's the defense attorney's opinion. Causation. Paragraph 26 of the response makes clear plaintiff's theory of causation is that their mental suffering and anguish increased when they did not know the well-being and location of Gabby Petito, and that the Laundries could have prevented additional suffering. To prove causation, the plaintiff must show that, but for the extreme and outrageous conduct, the severe emotional distress would have not occurred. By using terms such as increased and prevent to describe how the Laundries caused the distress, the amended complaint fails to satisfy the necessary elements that the severe emotional distress would not have occurred absent of the Laundrie's silence. If the distress was already occurring, plaintiffs have not alleged that but for the Laundrie's inaction, it would not have occurred. So they're arguing that because they remained silent and because their son had already committed this, the distress was already there. It wasn't because of their outrageous actions that caused it. I would say so. Blocking a parent that's looking for the child, not communicating with the child. I don't see how the parents of Brian had a right to remain silent when they are not the ones that are being criminal. Fifth Amendment is for criminal cases. Fifth Amendment is when you don't want to incriminate yourself. You have a right to protect yourself from incrimination. So, which is it? Constitutional rights likely realize that the Laundrie's exercise of constitutional rights could never qualify as outrageous conduct and is a complete bar to their action. The plaintiff attempts to weave around that problem by invoking rules limiting the court's ability to consider the issue at the motion to dismiss stage. In doing so, plaintiffs label the Laundrie as constitutional right as affirmative defense and complain that the Laundries are asking the courts to consider facts outside the four corners of the amended complaint. Neither issue saving plaintiff's amended complaint. So they're arguing that they're agreeing that they're arguing outside of the four corners of the complaint. You know, that's for a trial. That's what people don't understand. They're arguing what needs to be argued at trial, not at a motion to dismiss. And I think that's the sentiments I'm getting while I'm trying to read all this stuff. So it doesn't sound like they're happy with their response. Let's read the plaintiffs must be present. As the case cited by the plaintiffs plainly stated, in all cases we have found in Florida recognizes the tort of intentional infliction of emotional distress. The plaintiff was the recipient of the insult or abuse, or the message was clearly directed at the plaintiff through a third person. The amended complaint alleges no contact between the Laundries and the plaintiffs, so the plaintiffs received no insult or abuse, nor was any message directed at them. I don't know. Bertolino called the memorial of Gabby Petito litter. I would have to say that was directed at him. Directed at me. Wherefore, the reasons set forth the Laundrie's motion to dismiss, the Laundries respectfully request the court to dismiss the amended complaint with prejudice. I don't know if they're going to do that. I really don't. Guys, don't forget to like, give me the thumbs up this morning. I know this is a little bit different, but I wanted to read that for you guys. I wanted to let you know that I am going to be going to the court hearing. It appears that both parties will be present. If they're not, that's okay. I'm still going to be there. I'm going to still hear their arguments, and I will still report back to you guys this afternoon about what happened and, what what happened in the case. I'm interested. If I can run my phone from the courthouse and run live, I will. But I will be there, and I will report back to each and every one of you. Guys, thank you all for everything that you do for this channel, even being here. Just thank you. Without you, this channel would not be possible. I really do appreciate your input. I saw you guys were communicating. I'm sorry I didn't get to read your questions in here about this case, but we will get to a Q&A later this afternoon for you. That we will try to, at least I will try to give you as much information as possible, but we will do a Q&A this afternoon. So please stay tuned, and don't forget to turn your bell to all. We need your bell turned to all. You never know when I'm going to go live. I may go live outside there. I don't have a timing of when I'm going to go live, so you don't want to miss it. And we want to make sure that if you have questions, those questions are answered. God bless each and every one of you. Go make it amazing and a great day. And don't forget to be fearless, folks. Have a good one.
As you wake up in the morning, you want to find the latest, greatest information about criminal cases and have an intuitive conversation about the suspects associated with these cases. Head over to the Bullhorn Betty channel on YouTube. Get breaking news right here on the Bullhorn Betty channel. Welcome to the Bullhorn Betty Coffee Club. Enjoy your stay and enjoy your day.